Good evening. My name is Bill Edgett, and tonight I have Kelsey Green on with me. Tonight we're going to try to focus on different steps throughout the process of parental alienation and how to try to move through these steps to progress instead of getting stuck and having nothing happen with your case or having the situation stay the same. So, Kelsey, how have you been?
I'm good, Bill. How are you been?
I'm doing all right. You and I are both we communicate regularly, and we're both still fighting, and hopefully we can help some people and let them know how to progress the way we have. I don't
Yeah.
know that we've had much success, but we're still trying and trying to share the information we have.
Well, these are complex problems, and the holidays can be a difficult time for a lot of alienated parents.
Yes.
A lot of emotions wrapped up in the holidays. The attempts to try to see your kids, maybe get them some presents. Maybe you do get to see them, and then often that brings some grief back. So, to all the alienated parents that are out there that are going through the holidays, I hope you know that there are a lot of people out here that are pulling for you and that think you're important.
Thanks, Kelsey. And I over Christmas on my group there, the group that you helped me run, I put my cell phone number because Christmas Day after 3 p.m. I was alone, and I was alone on Boxing Day, so didn't have to work, didn't have to do anything. So I put my cell number out there for people to call me if they needed any help or support. And it's somebody else had done that for me, and it's helped me get to where I am now. So again, just trying to help other people. I'm just a father who's gone through this abuse and this process the same as you, and you and I have helped one another go through this. So,
well, it's a really complex process, and there's a lot of steps to it. There's a lot of people that don't want to help you, that make up a decision really quickly, and then stand on that decision because they don't want to look at evidence to the contrary. So I think in the last time we had this chat, we talked a little bit about how these start, how often the police are involved early on, or child protection's involved early on, and some of the challenges that neither one really are trained to look at alienation or coercive and controlling family violence and the behaviors that make up the two of them, because they are the same behaviors. So you get people in who aren't trained. They make decisions which are often based on policies or procedures in place that they say they don't have pro-charge policies anymore, but really that's how they act, and that's how they behave. In many cases, child protection often just wants to remove one parent from the scene, thinking that's best for the children. And so then you've got this story that started that's being written by people who don't know how to write the story. But the story started. So I think that's the first part that we talked about.
Yeah, that's where it kind of left off, the first few stages. And one of the things is you're right, the police and child protection, they don't always have the training or qualifications to properly diagnose these situations. And that's when these situations get a lot worse, because then you're thrown into the courts with judges and lawyers who are making decisions based on the law with no real concept of how traumatized people behave and how traumatized people this will affect how they present in court and affects how the courts make decisions in these matters. And that's what people need to really understand is how damaging how you present in court can be to your case.
Mm-hmm. And it's a really hard one because it's for a lot of people, it's maybe the most serious time in their life, the time where they've got the most on the line, and here they are showing up trying to do what's right. And if they're, you've got two people, and one thing that the courts really don't have the training in is to determine which one has a personality disorder or nearly has a personality disorder, and which one is traumatized from the abuse that's been happening. Yes. Not just since separation, but typically for much of the relationship, perhaps the whole relationship. So it's a unique proposition, and it's really more of a medical condition than it is of a legal condition in many ways, at least at first. In some provinces, including Nova Scotia, where I live, the criminal courts have a mental health court. So they defer certain cases where there's mental health to this criminal court that has, I believe it has a couple people on it, a judge, and then at least one mental health professional who has some understanding of the mental health impacts. And they don't have that for civil matters or for family matters. They don't have a similar court. And even though the Divorce Act and other legislation before that identifies that lawyers and courts are supposed to have the proper procedures in place to determine if family violence is happening, I'm not sure that I've seen any processes or any training by lawyers with anybody that I've spoken with. I have reached out across Canada, and I don't think those things are in place, except for maybe one or two isolated locations, from what I can tell.
And I agree. I think a lot of these cases, the lawyers and the judges who look at these cases look at reasons or grounds to justify making a decision in favor of one party over the other without really looking at the evidence because of the narrative and story that's being presented.
Yeah, it's absolutely. And you know what happens once the story gets started, then everybody just piles on. It's just a puppy pile on. And everybody jumps on saying, I'm going to hold up that story. And whether they do it purposefully or whether they do it because they don't know better, I'm still not certain. I like to give people the benefit of the doubt and think that maybe they don't know and maybe they think they're doing the right thing. But, you know, especially when it gets to lawyers and to court, it's not about, you know, the allegations that were made before. It's about the hard evidence in place. And, you know, if there are allegations that are made, well, if those allegations are true, then that often is a criminal issue. And if those allegations are false allegations, well, then false allegations themselves are a criminal issue.
Right.
So we end up getting into a situation where many families, many parents are in civil court dealing with issues that may be criminal.
And that's exactly the case. I think David Lametti just posted last week or this week that just passed new training program that they have to come out to teach judges how to recognize coercive and controlling behaviors, because this is what is needed. Without the recognition of this pattern of abuse, they, according to Dr. Stephen Miller, 95% of the time they'll align with the abuser to help further abuse the victim. And this is so detrimental and damaging to families and the children and extended families, cousins, relatives, grandparents. It affects everyone involved, and the judges just don't seem to be aware of the impact that this has on all these people, and that they're not making decisions based on all the information. They're making decisions based on a story of fear they've been told, and they're afraid to make a mistake. So the police have already chosen sides and child protection have already chosen sides. So I'm going to choose sides because they've already done that. And we're just going to maintain this until there's different evidence to show this isn't true. And even when evidence has been provided, like in my case, I lost custody of my children based on false allegations that were made on a Monday afternoon at about 4:30 p.m. By Friday afternoon at noon, my ex had sole custody of the children. And all it took was her making a phone call to child protection, then a phone call to the RCMP. The RCMP officer showed up in my home. I provided him the court order. I related the circumstances that were happening and that this was a violation of the court order. And I wanted to make a criminal report, and he wouldn't take it from me. He drove away. And by Friday afternoon that week, I had lost custody of my children. And even once the allegations and investigation by both child protection and the RCMP was concluded, the judge still didn't return custody to me. He said we're going to have a period where you're allowed to have visitation, and we'll go through this period, and then we'll come and revisit this issue and decide what the final custody and access order is going to be. So my children were taken away from me because false reports were made, which was a criminal offense. An actual investigation was conducted with the RCMP in conjunction with child protection, and I was cleared of both. It was proven the allegations against me were false without merit, and I'm the one who suffered, and my children are the ones who suffered, because during one of the visitation periods, my daughter looked up to me crying and asked if she could come with me. And I had to tell her no. So that was very difficult for me.
Yeah, absolutely. And the challenge with all this is you're building and building trauma responses into people. This is being forced into people by the failures of the systems, the inability of the systems to deal with these challenges and to deal with them in a timely manner. These things need to be addressed quickly. You know,
Yes.
I know people who've for more than half of the children's lives have been dealing with this. Some people who I think it's been 13, 14, 15 years of the children's lives, they've been going through this situation, and these issues need to be resolved as soon as possible. And as soon as possible is not 15 years later.
No.
It's, in my opinion, it's within a year at most.
Well, they need to be identified.
Yeah, and that's the issue that I continue to see is everybody thinks they're managing the risk. Well, we'll just keep the man away, or we'll just keep the mother away because she's crazy, or the man away because he's angry, you know. And they think they're managing some kind of risk, but they don't understand the risk. They don't do a full risk assessment. They don't understand by keeping a parent, a mother or father away from the children, that is adding risk to the situation and potentially adding harm to the situation.
Yes,
you know?
and all the studies that I have seen, and I think you as well, show that having both parents in a child's life, even if it is a high conflict situation, is better than being denied, a child being denied access to a parent. That every expert that I've ever seen who has written about this agrees that taking a child away from a parent is damaging.
Yeah. There needs to be a way for bona fide abuse to be identified, but allegations of abuse don't meet that threshold. So, there needs to be a really timely intervention to determine whether or not there is actually abuse that's happened or happening. And if there's not, then there needs to be some kind of repercussions for the false allegations that are being made.
I think you're right.
Themselves are abuse. That is another form of abuse. So,
I think you're exactly right. And when allegations of abuse, like you noted earlier, whether it's true, then there's abuse happening, which is a criminal offense, or whether it's false reports leading to an investigation is a criminal offense, public mischief, section 140 of the criminal code. This now has become a criminal matter. And before you can move forward in the civil matter in family courts, making decisions on allegations, and the civil court doesn't have the same burden of proof as a criminal court. So now you're using allegations of a criminal offense to influence civil matters, which is not supposed to happen according to the courts, because that's why each court is separate. There's a different burden of proof that needs to be met, a different threshold that's required to be met to make decisions.
That's
and
right.
It's like backdooring evidence. You can make up whatever story you want to the criminal. The police take the report down, they hand it over to a lawyer, the lawyer presents it in family court as if it's true. And that is the process that is currently happening.
Okay. It is, and it appears at times to be absolutely purposely done in order to gain that upper hand. It appears that perhaps even there are some lawyers out there who are telling their clients to do these kinds of things. Some parents actually go and get a lawyer before they get divorced and get a whole game plan in place, and they continue to do this. And when it doesn't happen, sometimes you get the police doing it. The police will say, well, we're not going to do anything this first time. We'll just take a report. But if you go and report it to child protection, or if you go and get an emergency protection order, now you've kind of got two feathers on one side of the scale, and you've got nothing on the other side of the scale. And so those feathers must be right. There must be some substance to them when there really isn't any substance to them. And in fact, in those situations, the police don't want to do anything. They don't want to get involved unless it's removing one parent from the lives of the kids. And then they do. So you run into a situation, and most people know that, in criminal court, at least here in Canada, it's in the US is a similar thing, is beyond a reasonable doubt. So that's a really high threshold. That's a very high threshold that has to be met. There's another threshold that's used in family courts called a balance of probabilities. So that means that I guess some math has to be done to figure out what the probabilities are. and then they need to balance those out. But essentially, that's looked at as being flip a coin, 50-50. Did it happen or did it not happen? So now in the criminal courts, the family of, the allegations would be proven false in many alienation cases, but you bring that into a family court and it's flip a coin. Could this have maybe possibly happened? And the courts go, oh, yeah, maybe it could have possibly happened.
You're right. I've had a criminal trial and proven innocent, and I had a judge sitting on the bench saying, well, that doesn't mean anything. Well, yes, it does. It means I'm innocent.
Yeah.
I went through a trial and I was found not guilty. That doesn't mean that their allegations were possibly true. It means they weren't.
There's a separate, and I've been in courtrooms where judges say these are separate matters and that's not to be considered here. But I've been in family courts as well where they go, well, actually, we're going to consider that just because it maybe possibly could have perhaps had some truth to it. But there's another threshold, another legal threshold that we don't talk about a lot, called the preponderance of evidence. So it's not quite the threshold of beyond a reasonable doubt, but it's more than a balance of probabilities. And I would argue in these family cases that there should be a preponderance of evidence for any judge to make a decision to remove a parent from the children's lives. And
I agree, because again, in my case, I've had to prove my innocence, and innocence doesn't need to be proven. Guilt needs to be proven, except in family court, where you have to prove your innocence in almost every case that of everyone that I've ever dealt with or worked with. They've been put on the spot and interrogated as if they're a criminal when they've been alleged to have done something, and even with the proof to show that the allegations are false. There's a case here in New Brunswick. A father was alleged to have molested his daughter, and it was proven by the police, by doctors, by professionals, and even a professional assessment that this did not take place. This did not happen. And in fact, the only person who believed this happened was the mother. And the mother suffered from this fixed and false belief. A fixed and false belief is a delusion. And if a person is continually subjected to a delusion, they will eventually suffer from the same delusion. And that's what the report indicated. And even though the report indicated if the child was left with the mother, who was delusional, suffered from a fixed and false belief, that she would eventually end up suffering from the same fixed and false belief. And the court awarded the mother custody. They don't know what a fixed and false belief is. They're making medical decisions, calling them legal decisions, and that's not appropriate in Canada in 2022. You're right, it's not. And that society has changed dramatically from the days when the judges, you need a certain amount of experience and time to become a judge. Currently, the judges are not in sync with today's society. Their views on marriage and relationships are completely outdated, and that is why the laws are changing. And even though the laws changed on March 1st of 2021 to recognize coercive and controlling behavior as family violence, David Lametti, the Attorney General of Canada, is posting that they're making training mandatory for judges so they are capable of recognizing coercive and controlling behaviors. Yeah, and the training is absolutely necessary. It's necessary for anybody involved with family courts, whether it's the lawyers, the judges, the court staff need that training as well. The parents who are going through it also need the training because they need to understand. Many parents have been experiencing various forms of family violence, and when you talk to a lot of people, you say, "Well, what's family violence?" And they think, "Well, that's just punching, kicking, stabbing, hitting, taking a baseball bat or a broomstick to somebody's head." But family violence nowadays is not just about physical violence. It's about psychological, emotional, financial, all of the components that make up coercive and controlling family violence. There's for coercive controlling family violence, there's reactive family violence. That's where there's family violence specifically to try to get a reaction out of somebody, and then they can use that reaction against them. Reactive abuse. So when we're talking about family violence, the challenge that we have in Canada that a lot of the quote unquote experts don't understand is there is little research into dads who are victims or and often they prefer to be called survivors of coercive and controlling family violence. So
we have legislation in Canada that is often has a gender-based lens to it, which does not adequately capture the experiences of fathers in coercive and controlling family violence. And I'll give you kind of an example. There's some research out of the UK into fathers who are survivors of coercive control that came out within about the last year and a half. And in that report, it talks about men's experiences and what they report. So men report being anxious, being depressed, being traumatized. But if you look at the legislation we have in place in Nova Scotia, we've got the Parenting and Support Act. So that's the act that's used when parents are not married under the Marriage Act. But the language in that act about coercive control says nothing about anxiety, depression, or any of the symptoms that men experience. But what it does talk about is the fear and being scared that women experience. So the experiences of coercive control are different based on the sex of the individual, and yet we've got laws that are gender biased. So if we've got laws that are gender biased, and we've got the federal government, trying to put in training, and they're hiring these people who are possibly gender biased, because we've seen a lot of these gender biased researchers and academics who really they get money because they push an ideology, not because they're being true to their profession. Are we going to actually get training that is gender agnostic, that talks about the differences? And
that's a great question, because Australia, they just changed their legislation for the next 10 years. They are looking to recognize abuse in the family courts. And again, the way it's worded, they're looking at men being the perpetrators of abuse. So they've already taken a position and have a preconceived notion of what the situation is before they even look at any evidence.
That never happens in alienation cases, does it?
That happens in every case.
Every day. Yeah.
So that's the government. That's the Australian government. That's how they want to move forward for their next 10 years. That's going to be their focus and their goal, is to help people that suffer from this coercive and controlling behavior. Because as it's coming around the world, like you said, the UK is doing a lot of work, a lot of study on this coercive and controlling behavior. And Jennifer Jill Harman, she refers to these types of cases as domestic terrorism. And I think that perfectly describes these situations, because when people are in these abusive situations, they're being treated the same as if they would be by a captor or someone who has taken them hostage, such as how the people from the Stockholm Syndrome incident tried to protect their captors after a very short period of time of being exposed to a cycle of abuse with intermittent periods of kindness. And this
and what's interesting
people.
about that one, Bill, is that years later, even when the accused, the bank robbers, went to court, many of the victims would refuse to testify against them, refuse to say anything bad about them. Like, that's years later, and that's what happens with abuse, and that's what happens with alienation. Not only, often is one parent confused about the situation that they could even be a victim of abuse. The children are saying the same thing or believing the same thing, and that can go on for a long time. So it's a terrible situation, and yet we really don't have any clear way to address it. So I've got a proposal. If we're not going to actually train people in gender agnostic terms, if we're not going to train people to really look at the core issues and not base the decisions on their own personal perspectives, their biases, then what we should do is we should have a rebuttable presumption of shared equal parenting. One that's a pretty high bar. Let's move to a preponderance of evidence, because until a parent actually proves that they're unable to care for children, well, they have, under the rights of Canada, and the children have under the United Nations Convention on the Rights of the Child, the responsibility of the government supports the relationship with each other. So, if we're not going to do this, and we haven't done it, and I've looked around Nova Scotia, and there are a couple of people who say they do it, but then when you actually dig into it, they're not really trained, they don't really know, and then they pick and choose what they actually help on. I know in New Brunswick it's fairly similar. I've looked across the country, and there's a few people, but there's some people who propose that they are experts in coercive and controlling family violence, and yet they don't understand that parental alienation is a form of coercive and controlling family violence. So we've got this whole mixture of people who want to help, but really just don't know how to help. And that's got to change. Or we've got to change the laws to actually help people. And we've got to hold judges accountable for when they're making decisions that don't fall in line with the rights of Canadians.
The evidence. Part of the problem of getting recognition of parental alienation is there's two groups that continually lobby against it. One's a feminist group, and the other is the Bar Association. So these groups continue to pay lobbyists to provide false information about parental alienation, such as parental alienation is a fabricated term by abusive men that want to see their children. It doesn't really exist. Now, this theory completely discounts the fact that women suffer from alienation at just the same rate as men, and it's so wrong for these people to be pushing this agenda, and that's what it is. It's an agenda. And the family courts, they're overburdened with and they're not qualified to make decisions on criminal matters because they don't have the same burden of proof. So instead of overloading our family courts, soon as an allegation of abuse is made, it should all civil and family proceedings should stop. And this should be moved to criminal court to be dealt with properly, where the court is capable of making decisions based on the evidence, and the burden of proof is on the person making the allegations, not the victim. And once it is determined which party is telling the truth, which party is the abuser, which party is the victim, then you can go to family court and make an informed decision in the best interest of the children. Because without that, it's a toss-up. They don't know what the situation is. All they see is two people arguing, and they don't know which is the abuser and which is the victim.
Yeah, that's right. Absolutely. When you look at it, I mean, there's different personality disorders, and to be clear, you don't necessarily have to have the full disorder to be an alienator, but generally, it's considered that you're pretty darn close, or you've got it. Narcissistic personality disorder is one, and those patients, they generally never get diagnosed. If they do get diagnosed, it's after they've committed a crime or possibly going to family court, but that's rare. So it's so rare that many psychologists who work with those people aren't trained, and they're not up to date on the narcissistic personality disorder, and probably wouldn't recognize it if it fell in their lap. The other one is borderline personality disorder. Yeah. And I think that's a growing one, and you can see that there's a lot of resources online about borderline personality disorder, and things to look for that you might identify someone with borderline personality disorder. But the challenge there is that 80% of the diagnostic criteria are the same for borderline personality disorder and for PTSD. So it takes a pretty good, pretty well-trained person, psychologist or psychiatrist or other, to make the determination as to which one, what are the difference, what's the 20% that's different in those 80% of the diagnostic criteria.
And that's right. Having the knowledge to be able to make the diagnosis and have an actual experience with people that exhibit those behaviors is what I like to refer to like a car driver. Say you get your driver's license. Yeah, you can drive, but you can't go get on a NASCAR track and drive around like Jeff Gordon. You can't do it. It takes years of training. And even though you can drive, you have the qualifications to drive a car, you can't drive it like that person. And same with professionals. Anyone that is a professional, there's different levels in that field. And a person who has the knowledge without the experience, according to Dr. Stephen Miller, can very easily misdiagnose these situations or overlook the fact that borderline personality could be a diagnosis because they see the symptoms of trauma and they're diagnosing this abuser as a victim of abuse instead of recognizing that they are abuser.
Yeah, absolutely. And there's different phases with that too, so somebody who has been abused for many years, as they start to put the pieces together and learn and realize that they've been abused, their perspective on the world changes. So how they present is going to change as well. And I don't think there's any education around how that perspective changes. What happens when somebody starts standing up for themselves and saying, I have been abused? Most people go, oh, no, you haven't. but they don't look at the evidence. They don't look at the facts. They don't say, hey, wow, this person is healing. They're actually getting better. And this is a big thing that we need to look at. No, they just sort of often continue with the same narrative that's already been started by people who didn't know what they were doing probably in the first place. One thing I'd like to touch on today is a report done, I believe it was late 90s, although it could have been early 2000s, called For the Sake of the Children. And this was a report done by Ottawa. And you can still find it online, although it is hard to find now. But this report effectively identified all of these same issues over 20 years ago that we're still dealing with, 20, 25, 30, 20, 25 years ago, that we're still dealing with. You know, it talks very specifically about some lawyers not being the most upfront and most, acting in the best interest of the child. And what's interesting about lawyers, and I may have the order reversed, but people can call up their local bar associations and find out. Lawyers have a duty to the law. So their first duty is to the law. The second duty is to the profession. I think it's the profession.
Maybe. I remember.
And the third duty is to the client.
But their first duty is to the law, and that's one of the first things they learn at law school. And
and I think the second duty is to the profession, because if there's a conflict of interest, they have to remove themselves because that would look bad on the entire profession. So, and then the third duty is to the client. But the interesting part there is, who is the client? If a parent comes in with a child, who is the client? Is it simply the parent, or is it the parent and the child? Now, depending on the bar association you go to, many of them will say when family matters, it includes the child, because it does include the child. But most of them won't hold their members accountable if they're not acting in the best interest of the child. And in many places, there is a sorry, here I'm just having a little seniors moment. In many places, they also try to be clear that there is no duty to act by a lawyer to act in the best interest of the child, which seems very much against the entire premise of family law.
Yeah.
You know, we've got the Divorce Act that says all parties shall act in the best interest of all parties. Anybody who has parenting time or contact time shall act in the best interest of the children. You know, we go to court and the judges are making decisions on the best interest of the children. Mediation, I believe, actually is supposed to act in the best interest of the children, at least to some extent, not always that it happens. But then we get to lawyers, and while there is some duty to the child, which one would assume is acting in the best interest of the child, generally it's considered that lawyers don't have that responsibility in Canada. So the system breaks down right there. If the lawyers don't have that responsibility, but the rest of the people and parties and the judge themselves all have that responsibility, you know, we've got a disconnect. We've got a broken chain. We've got an issue that needs to be addressed.
I agree completely. It's there's so much that is wrong that, and again, if we started moving some of these cases to the criminal court to be dealt with there prior to going into family court, it might prevent these cases from dragging on for 6, 7, and 8 years without a trial in family court.
Absolutely. So the report For the Sake of the Children, if you can search it online, you can find it on the government's website. Many MPs have access to it and can get it for you. Sometimes you have to go into the Internet Archive to look it up. You can also go to the Internet Archive to look up old government websites where there was violence against men, spousal, husband abuse websites that have been all taken down in early 2000s. There's none of those are on the website anymore, although there's many websites of violence against mothers and women. For the Sake of the Children report is really one worth reading, and it may be even one worth submitting and sending to your local politicians and saying, look, this has been identified 20, 25 years ago, and we're still having the same issues. What is going on? It really identifies all of these issues, the custody issues, the issues with the lawyers, the issues with the courts, the issues with not understanding what's going on. It's all been out there for 25 years. And for the, what we've got now is we've got the federal jurisdiction trying to make changes. And we've got many of the provinces supporting those changes very strongly, and some provinces that are not at all. So we have some provinces who are actually saying, don't tell us what to do. We're going to kind of do our own thing. For example, and I can speak of Nova Scotia because I do have some insight in Nova Scotia. Nova Scotia is getting ready to is underway and rewriting their domestic abuse policy for public prosecution. That domestic abuse policy has been around for about 20 years and has not been updated in 20 years. And as we know, a lot has changed even in the last 6. So it is a challenge. But there needs to be continued awareness brought to these issues. To make a change, we need the legislators to know that there are a block of people who will be voting against them if they're not willing to make these changes.
Yes.
And right now, that block of voters is growing very quickly. There is something that's changed in the last few years, in the last probably about 10 years, that I think is quite remarkable, and I think is going to be a real game changer. And I don't think that politicians, lawyers, judges, psychologists understand this, is that the knowledge is now not protected behind walls in professions. The knowledge is now public knowledge. It's easily and readily accessible to people. If you want to learn a subject and become an expert, you don't have to go and study for 4 to 8 years or 12 years in university. You don't have to spend all that time and money. You can be an expert by doing the work and doing the research, but you need to know what you're doing. You need to find the right people, the right reports, the right peer-reviewed articles, the right publications. You can find all that stuff. You can find the law. You can go back and find all of the law and history on alienation that dates back for over 200 years, looking at the British system in the UK and in the US. You can go and find the case against Moldova from the European Human Rights Court that says these are special populations and they need to be treated as special populations, and they're not. Like, all of this information is at your fingertips. And what's really kind of neat is we've leapfrogged many of the senior lawyers and the senior judges who don't understand how technology works and don't have access to this. So we've got people who can bring all this information to courts, but what it does is it entirely overwhelms an antiquated system, a system and people who are trained not to look and change and move. I mean, I've heard it described, and I think it's an interesting description, is that, if you have a judge who's 70 years old, they were educated 50 years ago, somewhere in their early 20s, 45 to 50 years ago. As a lawyer, they would have had to continue their education, at least to some extent. Usually there's continuing professional education that's required. Doesn't mean they had to do it in an area that was relative to their profession often, at least in the old structures of CPD. But as soon as you become a judge, you no longer have to do continuing education. You can choose to if you want, but there's nobody who can make a Freedom of Information Act request for it. There is nobody who can look at it. So you can sit on your butt and not do any education. 82. So that means closer to 60 years ago they were educated. And if you think about that, you go, well, who were they educated by? Well, they were educated by people who were educated at least probably 30 to 40 to 50 years before that. So we've got a system where the knowledge in the courtroom could perhaps be as old as 80 to 100 years out of date at times. And we have people walking into that courtroom who have access to, YouTube, to tons of information that's being put out there for free. You have, just going on YouTube, you can pull up any expert from around the world in any one of these areas, and you can listen to not only, 10, 20, 30, maybe even 100 hours from these people. But you can listen to all of their contemporaries speaking about all of these issues. It's not unreasonable for some parents, especially those who go through alienation, to go like, what am I dealing with? I don't understand this. I don't know why anybody doesn't understand it. I know a lot of parents who've listened to 50, 100, 200 hours of YouTube videos from the experts. So this is information that the judges don't have. This is information that the psychologists don't have. The social workers generally don't have, because they're they're not invested in it. They don't have
No.
skin in the game. And then you've got judges and psychologists and lawyers who are all trying to make decisions for people, and they don't have to live with them. So in the end, they don't really care what the decision is as long as the matter goes away. They get their money, they make a decision, it goes away. And who's left with holding the bag? It's families.
Yeah, there's a couple of things I'd like to touch on there. One was Richard Gardner, who first recognized and labeled these behaviors of parental alienation as parental alienation syndrome back in '87. And for coming out and making this recognition, he was labeled as a pedophile and is still known in some areas as a pedophile today. And he was not. He was a child psychiatrist who was trained at Harvard. And he recognized a pattern of eight definitive behaviors that were associated with parental alienation, and his recognition of this, what he labeled as a syndrome. It has since been condensed, and there's two models now being used to identify parental alienation, the 5-factor model and the 4-factor model. And both have been peer-reviewed and have been proven to be very effective at recognizing cases of alienation.
Yeah, so I mean, the whole Gardner thing is so funny because it's all the same behaviors that are being thrown at Gardner, trying to mudslinging and trying to get stuff to stick against the wall. But
yes.
You know,
they can't discredit the work.
The reality is
try to discredit the person.
That's exactly what it is. I mean, it's the same behavior that alienated parents get. I mean, oh, you're on to me, so now I'm going to make stuff up and go after you as a person, thinking that I can get back at you. And the funny thing is that, and Scott's right, the child protection and the courts often support those behaviors. They think those behaviors are acceptable, but they don't realize the harm that they're doing because they're not trained. And I'd like to, you know, there's a lot of people that get into Gardner, and you can go back through, and even Gardner actually wrote a paper, you know, countering some of these incredulous allegations that were made against him. You know, with a serious allegation, there needs to be serious evidence that comes with it, and there is no evidence to a lot of these allegations. But even before, you know, Gardner took on the task of trying to identify this, there's a ton of research that went into these behaviors before that, like looking at Murray Bowen and Salvador Minuchin, who were contemporaries, who were building on structural family systems. You know, they're identifying, you know, what's some pretty serious trauma in people going through these families, that there's triangulation, that there's boundary, there's enmeshment. You know, Jay Haley's another one that talks about those issues. You know, John Bowlby talks about attachment and loss, and when you look at him and Mary Ainsworth later in life, you know, they're talking about the same issues too. Like, it's not that Gardner was, you know, creating something out of thin air or anything, but it was that at that time in the world, he now had access to a significant number of serious cases of alienation that nobody else in the history of time ever had the ability to connect with. You've got millions of people. You've got the divorce rate, which is now soaring because divorce acts are going through. You have, you know, a lot of societal challenges. I mean, people weren't as well off as they are now. So money meant a lot. So there's a lot more than it does now. And even now it's precious. There's a whole bunch of things that came together, but the reality is that the evidence of this goes way back, even Greek mythology about Medea. You know, that's a Greek myth that talks about alienation, and including a parent in one of the iterations of it of killing their own children. So this isn't a new subject. It's not anywhere near new. But between 2016 and 2020, 40% of the research in parental alienation has been published. So that's a huge amount. And if psychologists, social workers, lawyers, judges are not current in those last sort of 6 years, well, they're probably missing out on half or more of the science that's happened in this area.
Yes. Now, there are people that, like Brian Ludmer in Canada, he is a lawyer who is very familiar, Gene Coleman. There are lawyers, there are law firms, and there are people and experts that are able to testify, and they are professionals, and their testimony has made cases change based
Mhm.
almost solely on their testimony because they
Mhm.
recognize this pattern. And that's that's the sad truth of where we are as alienated parents. We can't afford these professionals most times, and
No.
without those professionals, we're not getting the support or help we need or the recognition of this pathology in the courts. And that's what allows these situations to go on for years. And I think you might agree with me on that, Kelsey. You and I are in the same boat. Where I think we both have become well informed about this subject,
Mm.
and we can go
Yeah.
and present the this information to judges, and they look at us like, well, you're not a professional. No, you're right. Let's get one in here because you obviously don't understand what I'm presenting to you,
Yeah.
and you're not making decisions based on this evidence.
And and you know what? To some great extent, it's not. It shouldn't be up to the individual who is being alienated, who is being abused, in order to present the case. Like these are screenings that should happen prior to going to court. You know, in most provinces, parents have to do a parenting assessment or a parenting class. I guess, sorry, not an assessment, a parenting class. But you know, if you look at some provinces, they've started trying to put in the MASIC 4 screening tool so that parents do that as part of the going to court, and that's hopefully helps to identify the abuser. But you know, I really struggle because judges are wise. They don't get there just because they get there. They get there because often, and maybe not always, but often, you know, they're able to see things that are happening. They're able to make decisions on them, and I struggle because this is not rocket engineering. You know, this is human behavior, um, and you know, it's not complicated. It's just understanding a few fundamental issues, and then being able to make a decision. And overwhelmingly, it should be, how do I get both parents involved in this child's life as soon
Yes,
as possible? As soon as possible. And
yes,
just because children haven't seen a parent for a week or a month or even a year doesn't mean that there should be a huge, long stepping stone to getting back to 50-50 shared parenting.
mhm,
And I would argue whatever parent is fighting against that is the one who is probably uh, perpetrating some form of coercive control. They're not wanting to go to 50-50. Now, that's to say that, you know, there are some parents who've been alienated and they look at this and go, geez, you know what? The standard is, if it's severe alienation, that a minimum of 3 months of protected separation are there. It allows the children to rely on that parent solely and individually to rebuild that relationship. Um, so, you know, you got to look at that. But it's not about going with your gut. It's about looking at the facts. It's about looking what's happened. And yeah, and it's got to move
yeah.
faster.
It does, and I think they're looking to just establish the status quo because that is the pattern they have. It's like that old story of Grandma's ham. Um, the daughter cuts off the shoulder of the ham, puts it in the oven, and the husband asks her, "Why? Why do you do that?" "Well, my mom always did it." So they call the mother and they asked her why she did it. She says, "Well, I saw my mother do that." So the next call is to the grandmother, and they asked her why she cut off a
Mm-hmm.
perfectly good section of ham. And she said, "Well, we had a small oven. So for me to fit it in the oven, I had to cut a piece of it off."
Mm-hmm.
Now, that there
Tradition.
just shows that people learn
Oh my
and
God.
mimic
Yeah.
what they see, and they
Yeah.
don't always understand what they're doing, which is why these cases need to be recognized and identified. Because
Mhm.
if one parent is displaying alienating behaviors, coercive and controlling behaviors, the children can recognize that, even if they don't know what it is, and then start mimicking these
Mhm.
behaviors, which is what Dr. Craig Childress says are the fingerprints left on by the coercive and controlling behavior. The 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 signs that they have been subjected to coercive and controlling behaviors, that they have been manipulated. And
Mhm.
if people don't know what they're looking for, they're never going to see it.
Mhm. Yeah, absolutely. No, it's so much of what we do is tradition because it's, in some level, it's comfortable. I know what to expect. I know where things are going to come from. I don't have to learn. I don't have to move or think or change my perspective, my lens on the world. But the reality is, we live in a time where information is being developed at a rate that has never been equaled in the history of time. And if we have our institutions not changing, not evolving, you know, we don't want to do, would we want to do medicine like they did 100 years ago with leeches
And,
and ether? Like,
yeah.
no, everybody would die of cancer and we wouldn't have insulin. Like, we've got to progress, and the systems that we've got are not progressing. And there may be many reasons why that is, but it's time that those systems progress and change and modernize. It's time that we remove this uncertainty, this perception of risk that can't be quantified or can't be understood or can't be communicated, and therefore is just used to remove a parent. No, we need to, the default needs to be 50-50, and we've got to have a very good reason as to why you move away from that default. And that default, that if you're moving away from it, it's got to be more than an allegation. That's one of the key elements that we see in alienation cases, is that there are false allegations. So you need somebody who is wise enough, who can understand and evaluate what isn't a true allegation, what's a false allegation. And if the courts want to download that risk to psychologists or social workers or other experts, then so be it. But make the training available, download that risk as necessary, and hold those people accountable, because those people shouldn't also be trying to download the risk. Well, I'm not sure, so I'm just going to say no to this this person being involved with their kid's life. It's just wrong.
The courts, they reward people for lying by giving them custody until it is determined whether or not this allegation was true or false. So they continue to abuse the other party because they're getting support from the court and from the police and from child protection and the other agencies that are supposed to be there doing things in the best interest of the children, instead of taking sides in a custody and access matter.
And the other thing that I see that happens all the time is once a judge gets involved and starts to make a decision, it can be a tiny little decision, but once a judge makes a decision, then you've got groups like child protection, the police, public prosecutors, all of these other groups that kind of just go, oh, wait a second. Even other judges go, well, that judge made a decision. I don't know that I want to go against them. And it kind of sets up the dominoes and knocks them down, that nothing, you need something serious in order to change. And by that time, sometimes it's too late. Even appeals courts may be really scared to overturn a lower court judge's decision if it goes against the law. Even if it's not founded in evidence, if it's just, effectively a padded personal judgment that they've made against somebody, but that's still a judgment, and people don't want to go against it. So we've got agencies like the police who are seeing criminal issues happen. If somebody is withholding a child against a court order, the Canadian government put in Section 282 of the Criminal Code that says, what is it? Abduction.
Any parent keeping a child in contravention of a court order can be charged with an offense up to 10 years in jail for keeping a child in contravention of a court order. Section 282, and 283 is if there is no court order in place.
Yeah, and as soon as the courts are involved, they don't want to deal with it. They don't want to look at it. They don't want to consider it. They won't touch it because the judge has already had their fingers on it, and the judge has their fingers on it often after police and child protection, make their smudges on the lens, and then the judge gets it and puts a few more on there.
Yes, and it's funny you should mention that, because there's something happening with the case in Nova Scotia currently, where just such a situation is happening. Person's trying to access their court documents and they're not there; they're with the judge. So, how does that even happen? You can't go to a courthouse and access your file because it's with the judge, and you don't have any family proceedings going on at this time.
And it's a public file. It's a file that anybody should be able to go and access. You just can't publish that information. I do want to say, somebody here in the comments mentioned about an enforcement order, and sometimes people talk about enforcement clauses in orders. Often under the Judicature Acts of the provinces, all court orders are enforceable, whether or not they have an enforcement clause. But the police tell you they're not, because that way they can get out of doing it. Oh, no, it doesn't have an enforcement order, or the enforcement order is not clear, or it's a civil matter. There's always one more excuse as to why they don't want to do their job. And I mean, abdication of their responsibility may be negligence themselves. So, this kind of compounds, and it gets really, really messy, because once you start not following the law, and somebody else starts not following the law, then it compounds and gets really, really messy.
Yes.
And most people don't know
And
that. Most average people don't know that all court orders are enforceable, and that's the police that are choosing not to enforce them. And those people need to be held responsible.
that is correct. And before we end tonight, because we're closing in on an hour, and it's been great talking to you. I think we
Yeah.
covered a lot of information, but I think what most people would like to know is how do you move forward when you get in these situations. So
What are your
you go
thoughts?
right,
You want to go, or do you want me to go?
you go right ahead. How do you move
Okay.
forward?
Well, the first thing is you need to arm yourself with the awareness. For example, police can't tell if children are being emotionally abused, so they say they'll never move the children unless they're in harm's way. Well, now you got to start poking them and saying, well, you're not able to determine if there's psychological or emotional harm happening here. Those children need to come. You need to inform them about the laws of the country. Most of them have never heard of Section 282. You also need to make your FOIPOPs, your Freedom of Information Act requests, or access to information requests if you're dealing with the RCMP, and you need to get that information and get those in stream going, because that will start to scare them about, your rights, and you are going to get that information. You're going to expose what they're writing in the files. And you do that with child protection as well. When you go to court, you need to ask for everything. You need to talk to staff, and staff generally want to help. Generally, staff understand the issues that the judges create or the system creates around the judges, and they want to help. So ask them, be nice to them, ask them to help you understand what can you access from your file, when can you access it, how do you get through it. There's also often running files and other files that are kept from the courts that are part of the court. Now, Nova Scotia has just changed their policy that they don't want to release what's called the running file, which is really brief notes that staff take during any court proceeding. That information is public information, so for them withholding it may be a violation of your rights as a Canadian, because it is information about you and your matter that you should be able to access, and which up until about a few months ago, you have been able to access and actually get a paper copy of it. So ask staff what you've got and what else there is. You've got to learn the process. So learn the justice process. You've got to be able to push back. You need legal precedent. So you've got to look at alienation cases. You've got to look at human rights cases. There's a BC human rights case that just came out within the last about a month actually, just over a month, about taking someone's rights away from being a parent. As soon as they start to take your rights away as a parent, then that pulls into effect, according to this BC human rights case, the Canadian Charter of Rights and Freedoms, which is this one over here. And those need to be considered. So if you're in a case and they're trying to take your rights away as a parent, you need to make them aware of the Charter and this BC human rights case. There's a whole bunch of alienation cases. There's a case in Nova Scotia. Finally, law has been brought to Nova Scotia from other provinces, checked for alienation. Williams versus, I forget it, but it happened in June of 2022. And it brings in a bunch of the law from across the country. One thing that's really important in there is that alienation is a process. It's not a one-shot thing. It's a process. So give an inch, take a mile. That's alienation. And it continues to happen after all these decisions are made. What have I missed, Bill? What are some other things to try to stand up for yourself and push back? It's a lot about learning, a lot about knowledge. So
it is, and you covered a lot, and I'm sitting here listening to you, and you have a lot more knowledge. You approached me a couple of years ago to ask me how to start in this process, and I basically passed on the knowledge that I had learned and what I had done and what worked for me and what did not work for me. And one of the things you've got to realize is when you go to court or you go to the police or you talk to someone, most likely they're going to lie to you and try to send you out the door. Then you become somebody else's problem. One of the examples of that is you go to the courthouse and you ask them for a form to file an appeal. Well, you're asking for legal advice, and I can't provide that to you. No, I'm asking for an administrative act for you to provide me a form so I can represent myself in this matter.
Yeah.
But they'll lie to you, and if you walk away, you don't file the appeal. Nothing happens, and problem solved.
Absolutely. They just want to keep you away. Another thing I would recommend is talking to managers, directors. Keep going up the line of command, up the chain of command, and get to people who have the knowledge, that have been around, that understand what's supposed to be happening, and ask them and push them a little bit. There are some parents who write complaint letters. They go to the professions, if it's a police or a psychologist, or even the judges have ethics. Now, the judges' ethics are interesting. They're aspirational. You go to any other profession out there, they are held to their professional ethics, but not judges. They say specifically these ethics are not related to having a judge removed from their seat. They're aspirational. They're the only ethics in Canada for profession that are aspirational. Yeah,
That's
thick.
crazy.
And those
That's
just came out
amazing.
in the last couple of years. They just republished them, so it's not like it's 20 years old. It's 2 years old.
Okay. So you and I, we've spoken a number of times on trying to create resources for people to represent themselves. Each province has their own public legal education information system. You need to start there and start learning the Family Services Act or whichever it is for your province, because each province creates their own Federal Service Act. The Divorce Act is federal. It's for Canada and it's applied to all provinces, but each province gets to make their own Family Services Act and how they deal with divorces and cases. So it's hard to learn the laws for each province because each province is a little different. The best thing you can do is either get a lawyer from your province or start learning the Family Services Act so you can become informed. And when people start to lie to you about what the law is, if they're not a lawyer, they're providing you legal information which they're not qualified to give. And the people who love to do that most are the police. And dealing with them is very difficult. And you need to be very careful when dealing with them because they like to like to treat everybody as if they're a criminal, and they
can't tell the difference
they're
between
very
who's a
abusive.
criminal and who's not. Some in these family cases. Now,
Yeah, they're very
interesting. The
abusive in
police
their
is
behavior.
25 to 50% of their calls are dealing with family matters across Canada. So you think that they would be better at dealing with them, but they really don't know. So what they do is they just go and read the past reports, pick out what they like, and repeat it. But learning the law, connecting with others who've been through it, that does a couple things. One is it gives you some awareness of what you've been through or what they've been through, and what you may be going through. You can learn from their mistakes. You can learn from what's worked from them.
Yes.
That's really important. Those coaches are out there. Those people who are act as coaches in these situations. You've got to stand up to the judge, to lawyers. You've got to push back. It's a lot of work, and it's a lot of work for people who have been traumatized and abused in their relationships to do that. So you're going to need help. Yes,
you definitely need help, and I'm fortunate that I was able to maintain joint and shared custody of my children. Now it has been varied on numerous occasions during the past 7 years. This all began in 2015 for me, but paying for lawyers and going through the courts and trying to get help there isn't what helped me keep my children in my life. Having people that have gone through this process and were able to help me make those steps and recover enough to be able to represent myself instead of just staying where I was and allowing everything to pile on top of me and for me to just stay there. You need some support, you need some help, and you need to find someone who understands what you're going through, can identify what stage in this process you're at and treat you accordingly to provide you with the right information so you can move on to the next step in the process. And one thing that maybe I'll sort of just do a bit of a closing thought here. I know we're a bit over, and we could talk. We can talk more another time. But another piece that just sort of comes into my mind, because Scott has mentioned here about child protection wanting them to alienate their children from their partner, is that the police and child protection and judges, there is a net benefit to them if the alienating parent continues that behavior, because then it supports their case. It proves that they're acting with the intent, that if the parent supports child protection and removing the other parent from the case, well, then that's triangulation. And that means that the parent and child protection are backing each other up. So the child protection worker can't be seen as negligent because one parent thinks that they're correct. But so for alienating parents, or parents who it's alleged that you're alienating, you've got to really do a hard look at what's happening. You've got to really push back against the child protection and the police and say, look,
this is my kid's other parent. My kids deserve both parents in their lives. And if you're not willing to support it, you're negligent. And if both parents were to stand up against child protection and the police in these situations, if both parents were to collaborate, not only would there be probably quite a financial windfall in some of these situations, as we've seen in some parts of the US, but it would really stop these child protection workers, police officers, even lawyers and judges from making these just atrocious decisions that are going to harm your kids and your grandchildren and your great grandchildren. So if you're an alienating parent out there, really take a hard look and really see, like, because your other parent's involvement in your children's life is a lot more important than a lot of things. And if you're willing to trade that, then there really is a real challenge there. And don't let anybody push you into removing that parent from those kids' lives. It's not right. You will regret it later. Your children will wise up to it, and they will reject you later in life, and you will lose your children. If you want to keep your children, you need to keep the other parent in their lives.
I agree. You're right. Children need both their parents. They need the love and support of as many people as they can get, and to deny them access to a loving, caring parent is damaging to them, and it's wrong. And thank you, Kelsey, for taking the time to come on tonight and sharing the information. Thank you so much. You helped me a lot, and you've helped me a lot over these years, and I really appreciate the support you've provided to me, and I'd like to say thank you. So.
Oh, well, thank you for the invite tonight, Bill, and thank you for the support over the years. It's a challenging go for any parent going through it, so it's nice to have support and have knowledge that other people have gone through it and can understand what you're going through. So if there are parents that are out there, I know, reach out to Bill or myself online. You can find us online on Facebook or other places. So love to all the parents out there that are going through this. You're important, you're special, your kids do love you underneath it all, and as hard as it is for you to go through it, you're not alone. Yeah,
not alone. So yes, anyone who needs help, feel free to reach out. Like I said, Kelsey or I. My name's Bill Edgett. Can be found on Facebook. Just send me a message, and I respond to everyone who messages me. Yeah. Thank you very much, Kelsey. I really appreciate you taking the time to join us tonight.
Good night, everyone.